Good morning, reptile entrepreneurs. This is your host, Bill Strand. Today, we are going to be talking about patents. Patent is used to protect your invention because everyone loves a good idea. But the only thing better than a good idea is somebody else's good idea when they develop it, productize it, market it, and prove that it is a good idea. Unfortunately, it isn't so great when somebody decides to use all of your hard work for their benefit, and that's where a patent comes in that protects you. So it's worth spending some time learning about patents. I'm going to be bringing on Richard Clarke, who's a patent attorney. In fact, he's the one who helped me get my patent. And he's going to present an introduction to patents so you can determine if that is something that is right for you in your future. So please join me in welcoming Richard Clarke to the show. Welcome, reptile entrepreneurs. This is Bill Strand, your host, and today we're going to be talking about patents and trademarks. Because if you've had this idea and you're very excited about this great idea, you want to tell everybody in the world, but then you don't, because what if somebody takes that idea? Well, that is why we have people like Richard Clarke, who's a patent attorney and who's joining me today. Richard, welcome to the podcast.
Bill, I'm glad to be here.
Now, Richard, am I to be led to believe that there are people out there who would actually steal an inventor's invention that they worked on?
Oh, absolutely. Especially if it's a valuable invention. Anything of value is likely to be copied or there would be unauthorized use of. And in a lot of instances, these inventions are the core technology within a company, especially a startup or a small company, which becomes ultimately the value of the company. So it is important to protect your ideas, especially if you're going to move forward and commercially exploit them.
All right. Well, while I try to contain my shock here, could you give the audience an idea of what it takes to become a patent attorney and what your day looks like?
Well, in order to become a patent attorney, you have to become an attorney first, and that means you have to pass a bar from one of the states after attending law school. And then the additional work that you have to do is you have to take and pass a federal bar called the patent bar. And the only way to sign up to take the patent bar is to have some sort of scientific or engineering background, because patents are technical and the patent bar is a very technical examination. Once you pass both bars, you become a patent attorney, and what I do all day is I meet and talk with clients. I listen to their invention disclosures. I give them advice on how to move forward with protecting either their patents or their trademarks, and a lot of times both. And since I've been doing this for the last 28 years, I've really focused on startup companies and individual inventors that were starting a company surrounding their technology.
Okay, so let's start off with the basics. What is the difference between a patent, trademark, and copyright? Okay.
So the difference is, let's start with copyright because we're not really going to talk too much about that. If you write a book, a manuscript, a computer program, that written work can be protected by copyright. It cannot be trademarked, it cannot be patented. The only avenue you have for protection here is a copyright. Now this includes photographs, it also includes computer programs, it also includes website content, sequence and organization of databases and things like that, which do not fall into the other categories of protection federally. So copyrights can be really important for people who make movies, who write books, who write code for computer programs, and who take photographs. Trademarks, on the other hand, protect an image, a word, a logo, and possibly a slogan or all three together. And they protect that image, that word, in connection with promotion of goods or services. So when you see the Nike trademark, you know you're getting Nike shoes or Nike shirts. When you see the Crest trademark, you know you're getting your favorite toothpaste, Crest. These marks are protected because you don't want someone else to blur or tarnish your mark by putting out a really bad product under the same name. Patents protect two things. They protect ideas and concepts and also designs. There are two types of patents. A utility patent can protect a new composition of matter, like a new type of rubber or fiberglass or a composite. Apparatus patents or device patents can protect new machinery, a new tennis racket, a new lawnmower, anything that has moving parts and is function. And the final thing that a utility patent can protect is a procedure or a process or a method of either making something or using something. And the other type of patent is a design patent. Now, a design patent protects a new design for something that's already been patented and has been injected into the public domain. Let's take cell phones. If you come up with a new cell phone design, the cell phone has been invented for years, but you can get a design patent on your specific design. Also, a shoe design, a watch face design, a lamp design. All of these things, a new bicycle frame, all of these things have not been, are not able to be protected with a utility patent, but a new design of those things can be well protected by a design patent.
So how does the patent process work?
Okay, Bill. The first thing you have to do, it's a threefold process. The very first thing you have to do is you have to invent something, and it has to be a complete invention. It can't be pie in the sky or black boxes or a miracle happens here. It has to really be technically complete. Once you complete your invention, you would go to a patent attorney and you would give them a full disclosure of that invention in what's called an executive summary of the invention, explaining the problem that you've solved and all the different ways that you can solve it using your new concept. The second step is the patent attorney should run a full international patent search to see if anyone has done anything similar out there, because that's going to affect ultimately the prosecution of the patent no matter what country you file it in, or if you file an international patent application. The third thing is if it's clear, if your invention is clear and you get an affirmative patentability report from your patent attorney after the patent search, then you can build and file a patent application. So that's the third step. The patent applications are composed of three parts. The most important part of any patent application are the drawings. In some instances, very rarely, there are no drawings in a patent application. But in most cases, with a process or with a device, and even sometimes with a composition of matter, although more rarely with a composition of matter, you have to file formal patent drawings with your patent application. The second part of the application is the specification, and that specification describes your invention in excruciating detail, including every single drawing and every part name with part numbers for each of those technical drawings. And the final and most important part of a patent application is called the claims. And the claims need to be drafted by an experienced patent attorney, because this is where the rubber meets the road on a patent. If you have good claims, if you have solid, broad in scope claims, then your patent is going to be very, very valuable. If you have Narrow claims, your protection for your invention will be thin.
Okay. So at what point, say I come up with an idea, at what point is it appropriate for me to seek patent protection?
Okay, well, once you have come up with an idea and really worked out the details of that idea, I would say you should go to a patent attorney immediately and get the process started, because there's something called priority of filing date. And right now, it's a race to the patent office for your concept. If you're thinking about it for 10 years, somebody else may have filed it before you, and then you will be refused claims for that particular invention. So once you work out what you think is a valuable invention, you should get that disclosure to a patent attorney so that they can start a search for you.
Okay, and how much do I have to bring to that patent attorney for the attorney to do the job?
Well, in my office, I demand a full disclosure, which includes a paper and drawings that's called an executive summary. Now, some of the sections of that executive summary go like this. Describe the problem. Describe what others have done to solve that problem. Now describe your invention in detail. First summarize it, then show me some drawings, explain to me how it operates, and explain to me fully how it's constructed. And then at the end, I want to know some optional ways of doing it, and I also want to know some other problems that it could be applied to. That way, I can do a full and comprehensive search, patent search for that client.
Okay. Now, I've seen some people with patents that they have no way of building this patent of theirs. And this isn't in the reptile industry, so this is just a general patent question. I've worked with the consumer electronics industry, and these inventors, they come up with this grand idea that there's no way that they could ever manufacture it. And so they're walking around trying to find people to manufacture it for them. And so they're just the idea person. Do we have to have intentions of actually making this?
No, not really. Let me answer that in two parts. The first part is, if a client comes to my office with a new disclosure for an invention, and I actually think it's not going to fly, I'll let them know right away. I've got 28 years of experience. I know who's been successful in my stable of clients and who has not been successful. And I will discourage people from trying to patent something that they will never be able to commercially exploit. Now, that said, even though there are millions of patents issued there have been 10 million patents issued since Thomas Jefferson got the first patent in 1790, when he opened the patent office and he was the first commissioner of patents. There have been 10 million patents issued. Now, what percentage of those are actually commercially exploited and not just framed and put on somebody's wall? Less than 10% of them have been actually commercially exploited. So less than 1 million patents out of the 10 million patents that have been issued just in the United States have become a product or a process or a composition of matter that's actually been used in society.
Okay.
That's not necessarily a bad thing. The second thing that you need to know about that is when you come in with your concept or your invention, you should be considering whether or not you're actually going to build it yourself and make money through your patent that way, or if you're going to sell it to another company and license it to another company that is much better equipped to manufacture and distribute that type of product. So those are the kinds of things I counsel clients on every day when they come into me with an invention. I'll either tell them don't do it, or if you're going to do it, have an action plan moving forward that you will decide upon either selling your invention to a larger company, or you're going to license it to a larger company, or you're going to actually do the manufacturing yourself, which is a lot of work and takes years to accomplish.
All right. Some of us come up with completely original ideas, and those are obviously inventions. Then there's others that work off of what has been done before, and they change it in a material way. How much of a change needs to be done for it to be considered a patentable product?
That's an excellent question, and I grapple with that question every day. With regard to a utility patent, the protection is much more extensive because the protection relates to the functionality. And so it covers two forms of infringement. The first form is called literal infringement, and that means that you have every element of the claim within the issued patent covered in your article of manufacture, or composition of matter, or process. And that would be, a one-to-one identity with each element in the claims. The other way a patent can be infringed is by the doctrine of equivalence, which means if I patented a broom with a rigid handle, and my original broom in the specification had a wooden handle, and somebody came out with the same type of broom but had a fiberglass handle, by the doctrine of equivalence, that broom would be an infringement of my patent claim. So if you've got to, with the utility, functionality has to be changed a lot. There has to be a spark of invention, a creativity that makes it more valuable. And it won't be patentable unless that is the case. Okay. Now, with a design patent, that's different. We usually say that you've got to change at least 10 to 20% of the design. So if I have a design for a new lamp, let's say, that extends across the desk with an anti-gravity functionality, but it's just the design that I've patented, then you could come up with the same type of lamp, and if it looks 20% different, you probably aren't infringing. So with that, in that regard, a design patent has less protection than a utility functionality patent. And so you should be aware of that going in to your patent attorney and requesting a utility patent if possible, and then if not possible, reverting to a design patent.
Okay. So say I have a product that I manufacture, and I've been doing this for years, and then somebody else does something that's a little bit different, not that different, and then decides to patent that. What does that mean for me?
Well, first of all, the patent is obviously a sword as well as a shield. Let me explain that. The patent is a shield because once you patent something anywhere in the world, no one else can patent that anywhere in the world. It blocks. A U.S. patent blocks somebody in France and Japan and Germany. A German patent blocks in the U.S. and in France and in Germany. A Japanese patent does the same. So with that regard, once you've patented something, if somebody tries to patent something related or similar, the patent office will usually reject those claims. That's what the patent office is there for. They're there to ensure that no two individuals, companies or natural persons, have the same patent claim, because that would cause chaos in the marketplace. I lost my train of thought.
We talked about the shield.
The shield. Okay, now a patent is also a sword, because if somebody comes close to your claims, you can claim infringement. And I think that's what you were talking about in the beginning. So we do an analysis. If you think somebody's infringing your patent claim, and the patent has to be issued, it can't be just pending, then you should go to a patent attorney and show them what you allege are the infringing articles, and show them your intellectual property, and they can do an analysis. And if they feel that it's too close, they'll send a letter. And normally in my office, the first letter I send is a friendly letter. It says, hey, we've seen your product. Hey, did you know that we have a patent that's very similar? And hey, do you want to talk about a license? And we could have a win-win situation. Instead of hitting them over the head with a hammer and saying, hey, you're infringing. That never works. That just makes enemies. We're trying to be their friend because they're likely to be in the same industry, and they're likely to be going through the same struggles as the person who got the patent legally. In some instances, that's the case. In other instances, they're fly by night, and they just disappear after they get that letter.
Okay. But if you do get a patent on say I've been making something for a couple of years, but I don't patent it, and then someone comes along and patents something very similar, does that, can they patent something very similar if I've been doing it for a couple of years?
Yes, they can. And the reason is because patents are searched by the patent office, and they don't normally do a search of the products that are out there, for example, a comprehensive internet search. So once the product comes out and you notice it and you've been building it for a long time, you can object to their patent, which is kind of an expensive thing to do, or you can just wait until they claim infringement against you, and then you can prove to them that you've had this years before they did, years before they patented it. So normally the first affirmative defense to infringement is an invalidation of the patent. And the way to invalidate a patent very quickly and very easily is to show that you've already been selling these for years before they filed their patent application.
Now, there is a year limit. Once something hits the market, you've got to apply for a patent within a year of it hitting the market, or else I can't do the patent. Is that correct?
That's correct. The way that works is, think of it this way. The patent office will grant you a 20-year monopoly on your patent. In other words, no one else can make it, use it, sell it, offer it for sale, import it into the United States or any country where you get a patent, as long as you disclose it and file your patent application quickly. They don't want something to be out there for a long time and then have somebody file for a patent for it later. So the deal is this: within 1 year, you must file. Within 1 year of the date of publication, the date of first use in public, or the date of the first sale of that product. Okay? It has to be filed. If you don't do that and the patent office finds out, or your patent attorney finds out, your patent can be invalidated very quickly and very easily. So it doesn't make sense to wait more than 1 year. 1 year is a good amount of time, usually, to test a product in public. It's not a good idea to publish that because someone else could file that application within a year, and they would beat you to the patent office, and you would have a hard time explaining that.
So if I launch something and then somebody else quickly patented it within a month before I did, then they get the product?
They get the priority date, and you may have a big fight on your hands to stop their patent from going through to issuance.
Okay. So we talk about patent protection. Just what does that mean? I mean, we say they can't make it, but so we tell them you can't make them. They say, and they ignore us. What exactly does protection mean?
Okay, the bundle of rights for a patent, let's take the U.S. for example. In the U.S., the bundle of rights are as follows. The other people, they cannot infringe your patent if they make what you've claimed, if they use what you've claimed without authorization, if they import what you've claimed, or they even offer for sale what you've claimed. So that 5 bundle of rights: make, use, sell, offer for sale, or import into the United States. So let's say you have a patent on a new type of toothbrush, and somebody in China starts making them and tries to import them into the United States. We have custom and border protection that will stop those shipments from coming in, as long as you register your patent with CBP and you alert them that something may be coming in. They will stop it from being imported. If you have an idea that somebody in Nebraska is making these toothbrushes, well, then you can send them a letter and say, cease and desist, stop making the toothbrushes. Okay, and if you know of somebody that's using your patented process, you can stop that as well. That's a little bit more difficult to police as far as processes are concerned, because they're usually done in factories and in closed doors and in laboratories, and it's hard to tell whether they're actually using your process or not for the final product.
So say this person wants to push it and says, no, I'm not infringing on your patent. Where does it come to them actually being forced? What power do you have to enforce this?
Well, you can file for a patent infringement lawsuit in federal court. Okay. And that's really the only answer. A lot of times that gets done and then a settlement quickly ensues. If the settlement doesn't happen quickly, the magistrate or the federal court judge will demand mediation or arbitration or some sort of settlement conference well before anything comes near to discovery for a trial. So 99% of lawsuits, patent infringement lawsuits, settle before the trial even happens. Very few go to trial. The big shots, Microsoft, Apple, Qualcomm, they like to go to trial because they have a lot of money and a lot of attorneys, and they throw their resources at that. And usually those are multi-billion-dollar trials. But anybody smaller than them usually will settle before trial.
Okay. And who actually owns the patent?
Okay, well, when you file a patent, you have to disclose 2 things to the patent office. The first thing is you have to have a list of inventors, 1 or more inventors who played a material role in each or 1 or more of the claims. So that's very, very important. Inventorship is a very important requirement for filing a patent.
Okay. If
the inventors alone file that, they each own, like let's say there are 3 of them, they each own an undivided 1/3 interest in that patent when it issues. Now that's not normally the case. Like let's say you and I work for Microsoft and we have signed an employment agreement that everything we invent goes to Microsoft. In that case, the patent would be applied for in our names as the inventors, but in the name of Microsoft as the applicant. And in that case, the applicant would own the patent. So anytime you invent something for another company, normally they would own that. But if you invent it on your own with other individuals or solely, then you would like if you filed a patent on your own without any company and you were the only named inventor, you would own 100% of that patent.
Okay. All right, so let's talk about costs of a patent. And number 1, can we apply for a patent on our own? And what would be the cost of doing that? And if we went with an attorney, what kind of costs are we talking about?
Okay. You can absolutely file a patent on your own. There are a lot of resources on the internet. There's a book from Nolo Press that says patent it yourself. And if you follow closely and do a lot of research into the laws, there's no question that individuals file their own patents every day. I'm sure of it. And some of them turn out to be okay. Others turn out to be nightmares, and as soon as they get word from the patent office that has legal jargon in it, they run to a patent attorney, and a lot of times it's a rebuild process, which can cost twice as much. So the warning is this: if you think you're capable of doing it and you've done these DIY projects yourself before, go ahead and attempt it, but it could get very technical. And in that case, the costs are very minimal. I think one of the big costs will be that you've got to get formal drawings done by a patent draftsman. If you don't file formal drawings, you're going to run into all kinds of problems later on. They're going to reject the drawings, which they can do. You're going to have them redrawn, and if you try to add any new matter to the new drawings, you'll get a new matter refusal. So it gets kind of technical. I wouldn't do it unless you did it very meticulously, and the cost would be the formal drawings, your time, and up to about $1,000 in filing fees at the patent office.
Okay.
Now, if you go with a patent attorney, I'm going to give you the costs in my office, and you've got to understand that I'm a veteran. I've been doing this for 28 to 30 years, and my costs have gone up every year because I get things done effectively, quickly and effectively. And but you should understand that my costs are a lot higher than, say, a startup cost, a new attorney, a younger attorney that wants your business. And my costs are also about half of what you would pay if you went to a big patent law firm. So those costs are as follows. The initial consultation and all of the consultation are free. The patent search is $1,500 usually, and that comes with a comprehensive report of what patents are out there, and it also includes some consultation on how you might want to redesign your invention to avoid the patents that were revealed in the international patent search. And then to file one design application could cost anywhere from $3,000 to $6,000. That's the preparation and filing. And to file a utility patent can cost anywhere from $7,500 to $9,500. And that depends on the length of the patent, the number of drawings that are involved, and also the technical nature of those patents. So in the computer field, in the electronics field, in the chemistry field, they can be a little bit higher. In the mechanical field, you can be looking at a little bit lower costs.
Okay, and for the audience, the reason why I know Richard Clarke is because he's the one who did the patent for me, and I am very glad that I went through him because there was a complication, and he took care of that, and I now have the patent. And if I hadn't gone through an experienced attorney, I either would have given up because I had no idea what to do with what they were telling me, or that would have been the option, or else I would have just been on this hamster wheel of legal jargon trying to figure it out. The amount of time would have been immense to figure that out. So it was 100% worth it for me. And by the way, thank you, Richard, for getting
I'm
that
glad
through.
to hear that. I'm glad it worked out. Usually I am able to get the patents through. That's my specialty, and that's what I work on all day, every day. Sometimes it's hard. I've had some patents where I've had to in prosecution for almost 7 years.
Wow.
So let's talk about timing, okay?
Yeah.
Once you file your patent application, you have a filing date that no one else can beat. So anything that came before can be in conflict, but anything that comes after you that's similar or related will not be a conflict for you. So what the Patent Office does during their examination, which can take anywhere from 9 months to 2 years to hear back from them, with a utility patent now I'm talking, a little bit less with a design patent. The examiner will look at your claims, will read your specification, and then they will do their own search to try to knock your claims out. And they can knock them out in one of three ways. If your claims are not useful, and this is very rare, they're knocked out right away. So if you're trying to just claim a human genome or something like that, which you have not expressed any use for, that will not be patentable. The second thing is it has to be novel, which means that no one single patent or publication that came before your filing date has to encompass your entire invention. And the third one is it has to be non-obvious to combine one or two or three or more documents. Usually those documents are patent references or prior art references, as we call them. And they can't add up to your invention. Now that last one is arguable, and that's how I get most patents through, because most patent attorneys will try to apply patent A, patent B, and patent C and say, hey, out of these three, we've got you covered. You know, you've already got your claims in there. And I will argue no, that it's not the case, and we will amend the claims a little bit to get those through. So you normally will hear back from the Patent Office within 3 to 9 months on a design application, and within 9 to 24 months on a utility application. During that time, you're patent pending. The day you file, you're patent pending, and I encourage all of my clients to put patent pending down on their products, on their websites, on their brochures, on any promotional materials, if they go to trade shows, etc. Tell everybody, tell the world this is patent pending.
And then what is our obligation once we get the patent?
Well, the obligation is to say patented and to make it clear. Now, you don't always have to put your patent number down, but it's a good idea because let's say you have a website and you say patented. Well, they're not sure what your company name is, maybe from your website, or they get confused. So it's good to say that you're patented and put your patent number down. If you put your patent number down, they can call their patent attorney, or they can look it up themselves on Google Patents or some other patent searching website. And there are several good ones out there. Okay.
Do you have any interesting stories, patent-related stories that you can share?
Well, I have a couple. Let me start with the story that there are some invention corporation services out there, and they advertise heavily, and they're really shysters. I mean, there have been some horror stories that I've had clients coming into my office and literally in disbelief telling me that they've lost their rights to their patent. And not only that, they've lost the right to patent it themselves because of the botched job some of these patent or these invention support services corporations supposedly do. And then when I read the contract, of course, it's one-sided to them. And some of my clients have paid between $8,000 and $25,000 to have their invention shown around. And supposedly they expected it to also be patented, and it wasn't patented. And after a year of showing it around, the client can no longer get a patent. And I have to be the one that gives them the bad news. So lesson number one, don't go with these invention support corporations. They're a bunch of, they're just rip-off artists. And they know how to do it legally. There are all kinds of laws, especially here in California where Bill and I are, that try to protect the consumers against these, and the laws have been circumvented by these corporations that form these contracts that say, you give us all your money and we'll do what we want to do after that. And that's basically what it says. So avoid them. avoid them. Go to a patent attorney first. Don't come in later and say you got ripped off, because you may have lost your rights to the patent as well. The second thing is I kind of would advise people not to try to do it themselves. It's a complicated process. I've been doing it for 20 years, and I've been practicing for 20 years to try to do it right. And they change the laws a lot. I have to keep up with the laws. I have to do CLE. I have to take seminars, especially in the international area. And you could lose your rights quickly. For example, I've had clients come in and say, hey, I filed this, I got a response back, they say it's not right. And I take a look at it, and it's 2 pages. And it's a great idea, but there's no drawings, there's just a little bit of a write-up, and there are a couple of claims in there that don't make any sense at all. So you literally wasted your time filing that on your own. If you're good at it, if you can read a book, if you can follow instructions from a website or from Nolo Press, that's the best book that's out there. It's Nolo, N-O-L-O, Press. Patent it yourself. If you do it that way, you have a chance. But if you just think you're going to sketch out something and send it into the patent office, it's never going to fly. So that's my best advice. First of all, don't expect somebody else to do it for you. And second of all, don't file it yourself unless you're really skilled at writing.
Okay, Richard, I want to thank you very much for coming on and introducing us to patents and the process. It's definitely something for us to think about.
Okay, thanks for having me, Bill.
So what does this now mean for us? Well, you have to decide where you are in your product development process. I know many people, especially in the reptile industry, we are starting off and we're small, and you don't know where this product is going to go. You don't know if it's going to bring in enough money to justify the cost of getting a patent. Well, that's something that you're going to have to decide as to what's the future of this product. Once you release it into the public space, you have a year to decide before that window closes. You can decide that it's okay if other people make this kind of product. Just make sure you retain evidence that you've been selling it from the date you've been selling it. But if you think that you're going to be building a business around this product, then a patent is a very good thing to consider. Now, there's a middle tier here of companies that are established. They have a sales channel in place, and they're able to manufacture the product or have someone manufacture it for them. In that case, I highly encourage you to take a look at getting a patent. That's where I was when I made my dragon ledges. And for those not familiar, we in the chameleon world, we use a lot of screen cages, but we also need horizontal branches and potted plants up where the chameleons actually need them. And you can't put the weight on the screen. Well, people were trying, except screen isn't meant to be weight bearing, and so there'd be strain on the screen and structural problems. I invented a solution for that. I invented the dragon ledges, which is a brace and an anchor that goes across the cage. And what it does is it takes all of the weight of the plants and the branches and transfers it to the relatively strong aluminum frame and leaves the screen out of it. This was a novel, unique solution to the problem, and I was able to get a patent for that. So it worked well in my case. It was worth it in my case. And yes, I have had to defend that patent, although it was with somebody who didn't realize that they were infringing on the patent, and it was a very professional conversation. We resolved the situation. Now, it may sound petty to go after very small businesses that probably aren't a threat to me as a business, as an established business, but we have to consider that I am obligated to follow up on any infringement of the patent, or else it looks like I may have abandoned the patent. And what that means is if I don't enforce the patent, even with the small companies, a large company that has a very good sales channel can definitely affect my ability to make money from my invention. They can come along, they can copy it, and they can tell the courts, look, He's abandoned his patent, and so we can go ahead and we can make this. And if I haven't been enforcing the patent, that's a valid argument. And so if you do have a patent, you can't just sit back and lounge around and ignore the rest of the world. You have to actually actively enforce the patent. So keep that in mind. Once you get that, it's still a living situation that you need to deal with. Now, the next thing to consider is whether you're going to do it yourself or get a patent attorney to do it. There's a very good book that I've linked to in the show notes and I've linked to in the comments, and you can use that to help you through the process. Me personally, I went through a patent attorney to do that. Obviously, Richard Clarke, that's how I know him. And the reason why I did that is because I didn't have the time to figure out how to navigate through all of the bureaucracy. It may have been straightforward, and if I tried it, I may have gone through, but as it turned out, there was a complication. And so the patent office came back and said, there's a problem here. And it was Richard Clarke, my attorney, who was able to smooth it out. Would I have been able to smooth that out? Maybe. But it would have taken me so much time and back and forth. And I don't know if they would have respected what I had to say as much as they did Richard Clarke, who they actually know because he's been around for so long. So it was worth it to me to get somebody who knew what they were doing to do it because I didn't have the time. If you have the time to do it, go ahead, save the money, do it yourself. Go take a look at that book. People have done it. It can be done. If you're in the situation where your time is very valuable, then I would suggest that you consider whether it's better just to get a professional to do it. It's just like any of the myriad of decisions we have to make in a business. When do we do it, and when do we just pay somebody who knows what they're doing to get it done? If you're interested in getting a hold of Richard Clarke, I've got his email down below, and that's the way he would like to be contacted. Thank you very much for joining me here. And if any of you do go get a patent, or you're in the process of getting a patent, your patent pending, please let me know, because I would like to have a page on my website that lists the things that we are doing in the reptile community. And so if you're an inventor and you're getting a patent, please let me know. You can email me. You find my contact information on my website, reptileentrepreneur.com. And I'd like to show off what you're doing. And that is it for this episode. Take care of yourself. Take care of our reptile community. Let's see what we can build.